Hi, this is Marisa Portuondo. This is the 7th video in our litigation series, and I'm going to discuss depositions. In the last video, we discussed written discovery, which included requests for productions, requests for admissions, and interrogatories. Today, we're going to talk about another type of discovery, which is depositions. Now, a deposition is basically where a sworn statement is taken of a witness. And that can include the two parties, the defendant and the plaintiff, or if there are multiple parties, obviously, all of the defendants, all of the plaintiffs, anyone who is a party can be deposed. There are other people who may also be deposed who are non-party witnesses. Non-party meaning they're not a party. And a witness, obviously, meaning they have some kind of personal knowledge as to the allegations and the facts surrounding the case. So a good example would be, for example, in a property damage case, the homeowner is the plaintiff usually, and the plaintiff might be deposed by the insurance company's attorney. The plaintiff's attorney might depose, take the statement of an adjuster from the insurance company. And usually there is an adjuster that represents the insurance company as the party. So those would be, party depositions. Now, as far as non-party depositions, again, we use the example of a property damage case. Someone like a plumber, if it's a cast iron case, would be deposed. So the homeowner's plumber might be deposed by the insurance company, and the insurance company's plumber might be deposed by the plaintiff's attorney. You get the point. So what exactly happens in a deposition? I will say that I have yet to come across a client who is not nervous about the thought of being deposed and having their statement taken. Sometimes depositions can be video depositions, which means there is a camera there, you're being recorded while you're speaking, but there is always a court reporter present who will be there, will be typing up the transcript, and more often than not recording what you're saying, at least the audio portion of that. So it's extremely important that the client is cooperative with their lawyer in preparing for a deposition. Okay, depositions can be I've been to a deposition that lasted, maybe 15 minutes, and I've been to depositions that have lasted days. It really just depends on how complicated the case is, how complicated the issue that is, being discussed in the deposition is, and how detailed the attorney wants to get. Now, it's not to say that a witness can be abused by the other side, because if you have a good attorney representing you at a deposition, and the other side is just being obnoxious and just trying to get under your skin and waste everyone's time, then it really is up to the attorney representing that witness to say something and put a stop to that. But the attorney taking the deposition is a person, asking the questions. They have a lot of leeway. They can ask a lot of questions, and there's really not much that the other attorney can do as far as objecting. There are objections to form, which just basically says like, hey, the way you're asking that question isn't really proper. But more often than not, the witness will still have to respond. There are very limited instances when the witness doesn't have to respond, the most common being when something is asked that involves attorney-client confidentiality. And in that case, the attorney will instruct his or her client not to respond. So what else happens at depots? There are exhibits. The other attorney will more often than not have, a stack of papers, and they will ask the witness to look at the documents or the pictures or whatever it might be and talk about them. And all of this information gets taken down by the court reporter. You do swear once again that everything you're talking about is factual. You are under penalty of perjury, so everything is sworn and must be factual. With proper preparation, a deposition should not be something that is worth losing sleep over, even though I know that's easier said than done. But once it's over, it's over, and you will feel much better for having gotten past it. It is probably the most painful part of being involved as far as the client goes, direct involvement. But again, with your attorney by your side, it should be a lot easier and run a lot more smoothly. Alrighty, we will talk to you tomorrow.